Hi friends, hope all are doing good. We have already completed class 11 NCERT series Indian Constitution work. Now we are heading to M. Lakshmikant, known as Bible of Polity for UPSC. And here we will discuss all the important topics in polity through M. Lakshmikant. And today we will discuss writs in detail. So before heading to the topic in detail, let's understand what actually writs are. Writs are the orders issued by the Supreme Court, the apex court, or the high courts to restore the fundamental rights of the individuals. I repeat, writs are the orders issued by the Supreme Court or the high courts to restore the fundamental rights of the individual or the citizens. Right? And these are the important topics we are going to look at. Writs, types and scope. First we will see different types of writs and its scope. Then Habeas corpus, Mandamus, Prohibition, Certiorari, Quo-Warranto. These are the 5 writs available in India. Right? Yes. So habeas, actually these terminologies are somewhat unfamiliar to you. Habeas corpus, all these are Latin words. Habeas corpus means to have the body of. Mandamus, we command. Prohibition, to forbid. Certiorari, to be certified or to be informed. And Quo-Warranto, on what authority or warrant. So these are the meanings. And habeas corpus is issued by the Supreme Court or the High Court to a person when he or she detained another person. And mandamus, it's an order issued to a public office or to a person occupying a public office. Then prohibition and certiorari, these are issued against a judiciary or judicial body or quasi-judicial body, semi-judicial body. Okay. Then quo-warranto, it's also to a public office or to a person occupying public office. Hope you understood the very core of these writs, right? Yes. So let's start with writs, types and scopes. Scope, okay? Yeah. So both Supreme Court and High Court has power to issue writs, power to restore the fundamental rights of the citizens. And Article 32 provides Supreme Court to issue writs. Article 32, it's for what? Right to constitutional remedies. Right to constitutional remedies, right? So with that Article 32, Supreme Court can issue writs. And using Article 226, High Courts gets a power to issue writs, right? So both Supreme Court and High Court or High Courts can issue writs. Supreme Court using Article 32 and High Courts using Article 226. And these are the different types of writs: habeas corpus, mandamus, prohibition, certiorari and quo-warranto. Okay. Then before 1950, the provision for issuing writs was only for the high courts of Calcutta, Madras and Bombay. Right? Before 1950. That means before we got republic, only the high courts of Calcutta, Bombay and Madras had the power to issue writs. But actually the concept, it has been borrowed from English law, from Britain, known as prerogative writs issued in the exercise of the prerogative of the king, known as fountain of justice. Constitutional remedies or issuing writs is one of the most important features in our constitution, right? Yes. So it allows the Supreme Court and High Court to intervene in the matters of or the freedom of individuals, for the restoration of the freedom of individuals, right? Yes. So using all these 5 writs in different ways, it helps the Supreme Court or the High Court to get back the individual freedom or freedom of individuals. Hope you understood the logic, right? Yes. Next, let's see the difference or the scope of writs comparing Supreme Court and High Court. So, Supreme Court only for the enforcement of fundamental rights. That means Supreme Court can issue writs only for the enforcement of fundamental rights. But High Court, other than issuing it for restoring or enforcing fundamental rights, it can issue writs for enforcing ordinary law for other purpose, like enforcing ordinary law. You know what ordinary law is? A law made by statute, right? By legislation, through legislation. Okay. So enforcement of not only fundamental rights but also for any other purpose, like enforcement of ordinary law. Right? So we can say the scope of enforcing the rights is narrower for Supreme Court, but it is broader for High Court, right? Supreme Court can do it only for restoring the fundamental rights, but High Court can do it not only for fundamental rights but also for normal legal rights. So the scope of High Court is broader than what Supreme Court, right? Next point is Supreme Court can issue writs against a person or government throughout the territory of India. Supreme Court is the apex body. It has power throughout the country, right? Throughout the country. So its power to issue writs to a person or to a government throughout the territory of India. But of course, High Court, it has limited power, right? It has its own territory. So it can issue writs located within its territorial jurisdiction only. It cannot go beyond its jurisdiction. Hope you understood, right? Example, Kerala High Court can issue it only in its jurisdiction in Kerala, right? But Madras High Court, it can issue it in Madras territory, right? Madras jurisdiction. That means Kerala cannot go beyond its jurisdiction, cannot intervene Madras or Karnataka, right? Yes, okay. Then it may not refuse to exercise its writ. That is, Supreme Court cannot refuse or may not refuse to exercise its writ power. Okay, and the second point, the power of Supreme Court to issue writ is broader when we compare the territorial area, right, or territory. And the High Court is of course limited to its own territory. Okay, a limited geographic area, right? Yes. Then Supreme Court may not refuse. See the point? It may not refuse to exercise its writ, but High Court may refuse to exercise its writ jurisdiction. That means Supreme Court may not refuse to, but High Court may refuse to. Okay, so these are the different comparison points. Let's see one more time. Supreme Court can issue it only for the enforcement of fundamental rights, but High Court has broader power, not only for fundamental rights but also for ordinary legal rights. And territory, Supreme Court can apply or can enforce it throughout the territory of India, but High Court can only within its jurisdiction, right? Yes. Then Supreme Court may not refuse to exercise its power, and High Court can or may refuse to exercise its power. Okay, and of course we know Supreme Court is a defender and guarantor of the fundamental rights. We have seen this point many times, right? Yes. So Supreme Court is a defender and guarantor of the fundamental rights, or we can say Supreme Court is the interpreter of the Constitution, right? Yes. So hope you understood the different types of writs and scope. Now we are heading to all these writs in detail. First one is habeas corpus. It's a Latin word meaning to have the body of. To have the body of. And it is issued, the order issued to a person. Actually, habeas corpus is issued to a person who has detained another person. Who has detained another person to produce the letter before the court. Suppose I have detained another person and Supreme Court or High Court order habeas corpus to me or on me. I have to produce that person before the court, right? Yes. So it's to ensure individual liberty against arbitrary detention. So it ensures or it secure individuals from arbitrary or against arbitrary detention. Then he may set free by the court. He or she may set free. Then can be issued against both public authorities and private individuals. Of course, habeas corpus is one of the mostly used writ. You might have read these, writs in newspapers, right? Yes. So you are aware of it, at least aware of these terminologies, and how to connect with the scenario, right? Yes. So it can be issued against both public authorities as well as private individuals. Then it cannot be issued. Habeas corpus cannot be issued at the times when the detention is lawful. When the detention is lawful, like example, detention by the police. If it is lawful, right? Yes. So at the time, Supreme Court or High Court cannot issue habeas corpus. It must be unlawful, right? It must be an unlawful detention. When I have detained another person, it must be an unlawful detention, right? Yes. Then the proceeding is for contempt of legislature or a court. Actually, the proceeding is for contempt of legislature or a court. Then detention is by contempt of court. Then detention is outside the jurisdiction of the court. Okay, of course we have already seen it. Detention is outside the jurisdiction. At the time it cannot enforce, or it cannot issue habeas corpus. So this is all about habeas corpus. Habeas corpus means to have the body of. It is issued by Supreme Court or High Court to a person who has detained another person unlawfully, and Supreme Court will issue it to produce the letter, the detained person, before the court. Right? It's to secure individual liberty against arbitrary detention. He or she may set free. Can be issued against both public and private authorities. And we have seen which all situations we cannot apply. We cannot issue writs. Right? When it is lawful, when it is proceeding for conduct of court or legislature, then outside the jurisdiction. Right? Yes. So moving on. Next is mandamus. Mandamus means we command. We command. Who command? The Supreme Court or the High Court. Right? For what? Issued by the court to a public official. Not the point. Mandamus is issued by the court to a public official, asking him to perform his official duties that he has failed or refused to perform. That he or she has failed to failed or refused to perform or act. Hope you understood, right? When a public person is not properly working, or when a public person is not working properly, or refusing to work, or fail to work, at the time Supreme Court or High Court can intervene and asking him to performs the duties vested on him or her. Right? Yes. So at the time the court order issue what? Mandamus. Right? Yes. Can also be issued against any public body, corporation, an inferior court, a tribunal, or government. And it cannot be issued against a private individual. Okay, it cannot be issued against a private individual. You can see the first point, issued by the court to a public official. It can also be applied on any public body, corporation, inferior court, tribunal, or government. It's okay, there is no problem with that. And mandamus cannot be issued against private individual or body. Mandamus cannot be issued against a private individual or body. It can be issued only on public authority, right? Public, yeah. To enforce departmental instructions that does not possess statutory force, like private. To enforce private departmental instructions that does not possess statutory. Of course, private does not possess statutory, right? Statutory means by legislation. Yes. So the second point is about private individuals or private institutions. When the third one is when the duty is discretionary and not mandatory. When the job or when the duty is discretionary, not mandatory, at the time court cannot issue mandamus. To enforce a contractual obligation, at the time a person has to enforce or what to enforce a contractual obligation, contractual obligation against the president of India or the state governors. So it cannot be issued against the Chief Justice of High Court acting on judicial capacity. Of course, it cannot be issued on governors or president or High Court judges or judges, who is been some capacity, right? Judicial capacity or legislative capacity or executive capacity. Yeah. So these are the different situations where we cannot, or the court cannot apply, court cannot issue mandamus. Right? Hope you understood mandamus. It's a very simple concept. Mandamus means we command to a public office or to a public official asking him to perform his duty if he's failed or refused to do it. Okay? Failed or refused to do it. Yeah. Next is prohibition. Prohibit. It's a negative concept, right? Prohibit. To forbid. That's a word meaning. Issued by a higher court. Actually, prohibition and certiorari are related to what? Judiciary or judicial body or quasi-judicial body. A complete judicial body or semi-judicial body. Okay? Yeah. Issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction. Actually, here the main point is exceeding its jurisdiction. Right? Yes. So, it is issued by a higher court, like Supreme Court, to the High Court. We can say the Supreme Court is a high court and the High Court is a lower court. Or High Court to District Court, right? Yes. So to prevent the lower court from exceeding its jurisdiction. Of course, High Court has limited power. It has power. It can enforce the power. It can act the power only on its jurisdiction. It cannot go beyond the jurisdiction of the particular High Court, right? So it must not exceed its jurisdiction. If it tries to, or if it's happening, if it's happened at the time, the higher court can issue prohibition, prohibit in doing something, right? Yes. Unlike Mandamus that directs activity, prohibition directs inactivity. Don't do it. Don't exceed the limit. Don't exceed the jurisdiction, right? Yes. So Mandamus directs activity. Mandamus, asking a person to do his duty or her duty, right? That directs the activity to act on something, to do something. But prohibition directs inactivity. Don't do something. Don't exceed the limit, right? Yes. It can be issued only against judicial and quasi-judicial authorities. Judicial means complete judiciary, and quasi-judicial means semi-judicial authorities like NHRC, National Human Rights Commission. Okay, yeah. Similar bodies. Okay, yeah. They're not available against administrative authorities, legislative authorities, and private individuals or bodies. Of course, it can be issued only against judicial bodies or quasi-judicial bodies, both prohibition and certiorari, right? Yes. So hope you understood prohibition, right? Moving on. Next is certiorari. Certiorari means to be certified or to be informed. To be certified or to be informed. It is also related with judicial or quasi-judicial body, okay, issued by higher court or lower court. The previous prohibition, it was also issued by higher court or lower court, right, or tribunal, either to transfer a case pending with the latter to itself, that is to solve or to resolve the pending case, right? Yes. Or to scratch the order of the latter in the case, either to transfer a pending case with the or to itself. That means to consider a case. That's it. To consider a case, or to squash the orders, to scratch the order, to cancel the order, right? To cancel the order of the latter in the case. And previous, that is prohibition. It is to prohibit from exceeding its jurisdiction. But here it is to transfer a case to itself. That means to consider a case that is pending. Actually, yeah. Example: Supreme Court issues certiorari to a High Court, meaning High Court has some cases pending, and Supreme Court advising or asking the High Court to consider the case immediately, right? Certiorari example. Or to scratch the order. To scratch the order means to crash the to cancel the order, right? For example, here we can see, yeah, it is issued on the ground of excess of jurisdiction or lack of jurisdiction or error of law. These are the various situations or different situations. Higher court issues certiorari to lower court. That is excess of jurisdiction, exceeding the jurisdiction. Then lack of jurisdiction. Lack of jurisdiction, not properly working on judiciary, right? Or securing the law, or error of law, error of interpreting the law, error happening at the time of interpreting the law. So these are various situations higher court issues certiorari. Hope you understood the logic, right? Yes. Then unlike prohibition, that is only preventive, certiorari is both preventive and curative. Preventive and curative. When does it become preventive? To squash the order, to cancel the order, which has already been announced or declared, right? Yes. Then when does it become curative? When transfer a case pending with the latter, means pending with itself, to consider the case, right? So it is both preventive as well as curative. Curative means considering the case, and preventive means scratch the order, okay? Yeah. Previously, certiorari could be issued only against judicial and quasi-judicial authorities, but in 1991, Supreme Court ruled that it can be issued even against administrative authorities affecting rights of individuals. Okay, so till 1991 it can be applied only on judicial and quasi-judicial bodies, but after 1991 with the Supreme Court ruling, it can be applied, it can be issued against administrative authorities that affect the individual freedom or rights of individuals. Okay, then like prohibition, it's not available against legislative bodies and private individuals. So it is not available against private bodies or legislative bodies. It is available for what? Administrative bodies. Okay, administrative, only administrative bodies, not legislative bodies or in what? Private bodies. Hope you understood the logic. So this is all about certiorari, to be informed or to be certified. It is both preventive as well as curative. Preventive means to squash the order, and curative means transfer a case, right? And various situations: excess of jurisdiction, lack of jurisdiction, or error of law. Okay, yeah. And the last one is quo-warranto. Quo-warranto. It means on what authority or warrant? On what authority or warrant are you doing it? That's a very logic. Okay, if someone is unlawfully sitting in an office, anyone can approach the court for issuing quo-warranto, because he is not eligible. He or she is not eligible to sit or to be appointed in an office. Okay, he or she may not have enough qualification, enough experience, right? Yes. So issue to inquire into the legality of claim of a person to a public office. It is issued to inquire into the legality of claim of a person holding a public office or person to a public office. Okay, issued only in case of substantive public office of a permanent character created by statute or by constitution. It's only issued for institutions that are permanent character, like created by statute, legislation, or by constitution. It cannot be issued or cannot be issued in case of ministerial office or private office. Okay, of course it cannot be issued against ministerial or ministerial office, minister's office or private office. Unlike for other writs, unlike for previous writs like Habeas Corpus, Mandamus, Prohibition, and Certiorari, this can be sought by any interested person. This can be sought by any interested person. That means anyone can approach the court, and not necessarily by the aggrieved person. That means for the previous four, Habeas Corpus, Mandamus, Prohibition, Certiorari, the aggrieved person has to approach the court, right, to get his or her freedom back. But for this quo-warranto, anyone can, any public interest being can, citizen can approach the court. Not necessarily by the aggrieved person or the affected person. Okay, so this is what quo-warranto is. So this is done for to inquire into the legality of claim of a person to a public office. He or she may not be eligible to sit or to be appointed in the office. Okay, so these are the various writs, and I hope you have understood all the concepts and everything. Okay, so Article 32, 226 allows Supreme Court and High Court, then different various writs, English law from English, yeah, then different differences between writs of Supreme Court and High Court, then Habeas Corpus to have the body of we have seen detail, then Mandamus to a public office to official to perform his duty, then Prohibition and Certiorari, judicial and quasi-judicial bodies. Prohibition is exclusively for judicial and quasi-judicial bodies, but Certiorari can be applied not only for judicial and quasi-judicial but also for executive or administrative authorities that affecting the rights of individuals. Okay, but never to legislation of private bodies. Right? Yes. So this prohibition is inactivity, right? And certiorari is what? Preventive as well as curative. Then quo-warranto, on what authority or warrant, right? Yes. So hope you understood everything. This is a very important topic. Of course, you have to understand writs very well. Sometimes in your prelims as well as in your mains, questions questions have come in the previous years. Okay, so hopefully see you next time. You just start preparing notes. Okay, yeah, have a good time, take care.